Welcome to you, counsel. If you have received an unfavorable decision from a court, tribunal, or another administrative public body, and you want to appeal that decision, you come to this complicated world of appellate review. The appellate review world is complicated because the procedure for the appellate review is complex, and many experienced lawyers cannot agree on what the correct process is, and sometimes many judges cannot agree on what the correct process should be with respect to a specific appeal. In this lecture, we will try to explain broadly what this appellate review process is and give you a general understanding so that you can start the process of doing your own research with respect to the specific issue that you may be dealing with and you wish to appeal that particular decision. We begin with the disclaimer that this lecture is only for educational purposes and it provides you a very broad overview of the law relating to the process of appellate review. If you have any specific questions regarding your own issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. First and foremost, I want to explain to you that there is a significant constraint on the appellate review process. And this constraint is an appellate review is a review of error, not review by hearing. Now, this is important to understand because many people have this misconception that if they are appealing a decision, it somehow amounts to a rehearing of the entire case, a retrial or another trial, or reconsideration of the entire decision by an appellate body. But that is not the case. So the most important thing that you want to understand is that when you are appealing a decision, you are basically telling the appellate body that the lower court judge or the decision maker has actually made an error, and you have to explain that error, and on that basis the appellate court will decide whether that error was made and whether that error requires that the decision be set aside or overturned. So the scope of the appellate review is very narrow, and this is covered under the topic of standard of review. I will do a separate lecture on standard of review because that is another complicated area of law, and we will get into the details of how a court reviews a decision and what is the criteria in overturning or setting aside a decision. But for now, what you want to understand is that when you are asking an appellate body to review a decision, the appellate body is starting with the primary assumption that the decision made by the decision maker was correct, and then the burden is on you to show how that decision was incorrect and then what kind of remedies you may be entitled to. So it is not a review of the hearing, it is not another trial, it is simply a review on very, very narrow grounds of the decision that has already been made. Now we'll talk about appeal versus judicial review. These are two terms. These are not two different names for the same process. These are complementary but different processes, and they have different requirements that you should follow. So the first question that should come to your mind is that the decision that you are going to challenge or you wish to challenge, whether it is subject to a judicial review or whether you may be able to appeal that. Now, in most cases, you are appealing a decision where the decision was made by a court or another administrative tribunal. For example, you had a case in small claims court in Ontario and you received an unfavorable decision in that case. Your ability to challenge that decision would be by way of an appeal and not by way of a judicial review. In another example, if you have faced a decision before a human rights tribunal that is unfavorable, then you do not have the right to appeal that, but you will have the ability to seek or apply for judicial review. So appeals usually deal with the decisions of the court or a tribunal's decision, whereas judicial review mostly deal with the decisions of administrative tribunals or public. Now, some administrative tribunals may provide in their legislation that you may have a right to appeal, while other administrative tribunal in their relevant statute may provide that you may be able to apply for a judicial review. So we will talk about how to figure out whether a specific decision of an administrative tribunal requires a judicial review or with respect to public bodies could be public institutions, for example, hospitals or universities, which are considered public bodies, and their decisions, if you wish to challenge a decision of a hospital or a university, you may be able to challenge that decision by way of a judicial review. It will not be done through an appeal process. For you to determine whether your specific case requires following the appeals process or judicial review, you must review the relevant legislation and determine what is the appropriate process in the circumstances of your case. Let me give you some examples of cases for judicial review. Or let's say you are facing a decision of landlord and tenant board which was unfavorable. You were either a tenant or a landlord in this specific dispute and you received that unfavorable decision. The question for you is whether you can appeal that decision or you will have to ask for a judicial review. And the answer lies in Section 210 Sub 1 of the Residential Tenancies Act, which basically provides that an order of the board is subject to appeal. You can make this appeal to the divisional court within 30 days, and then the appeal is limited only on a question of law. Now, this part about the grounds for appeal being question of law is subject to the standard of review that I talked about, and we will discuss that in a separate lecture because, again, that's another complicated area of law with respect to the criteria that the appellate court will apply, in this case divisional court will apply, in determining whether it can make a decision, whether it on the specific appeal that you have submitted to that court. Another example is in case of a human rights application that you face a decision of the Human Rights Tribunal in Ontario, which is unfavorable to you, and you would like to challenge that decision. Can you appeal that decision or do you apply for a judicial review? And the answer lies in Section 45.8 of the Human Rights Code, which states that the tribunal's decision is final and is not subject to appeal. So your only option with respect to a Human Rights Tribunal's decision is to apply for a judicial review, and that decision can only be altered or set aside if it is considered patently unreasonable. Again, this wording, patently unreasonable, is relating to the standard of review that the appellate court will apply in making a decision on your appeal. As I mentioned, you will have to look at the relevant legislation in determining whether your specific issue requires a judicial review or the appeals process. And I have provided some relevant legislations that may be helpful to you. First of all, you will have to find out what is the most relevant legislation that is dealing with the subject matter of the underlying issue that you have. For example, if it was a human rights application, then your relevant legislation is Human Rights Code. If it was a landlord and tenant dispute, then Residential Tenancies Act may apply. If it's workplace safety insurance issue, then you're dealing with Workplace Safety Insurance Act, and there are other legislations that are dealing with certain specific matters. So you will have to determine what legislation, what statutes specifically deal with your issue. If any, your issue may not be related to a specific statute. It may just relate to common law, in which case it will not be subject to a statutory provision for appellate or judicial review process. But if there is a statute that is relevant, then you must review that legislation to understand what does the legislation say about your ability to judicially review the case or appeal. Also for judicial review, in Ontario, you would like to review Judicial Review Procedure Act, as the name implies. This legislation explains various processes for applying for a judicial review and the procedure that needs to be followed. Another important legislation that you should review is called Statutory Powers Procedure Act. For appeals, you would like to look at Courts of Justice Act, you would like to look at Rules of Civil Procedure and Practice Direction of the specific appellate court where you are applying for the appeal. I've given an example of Court of Appeal for Ontario Practice Direction, which can be found on these links. So I've provided the names of some of the legislation that will be helpful for you in determining whether your case warrants a judicial review application or whether you may be able to apply for appeals. Once you have determined that your case shall proceed with judicial review or an appeal, you will have to now deal with further complicated matters about what is the procedure for appeal and what is the procedure for judicial review, which we will try to cover in separate lectures. I'm hoping to provide a lecture on the appeal process in courts first, followed by the judicial review process. All in all, what you want to understand is that the appellate process is quite complicated procedurally, and you must carefully review the legislation to understand what process applies in your case. You usually have very limited time with respect to the appeal and judicial review processes, sometimes as less as 15 days from the day that the underlying decision was issued. So if you don't understand any of these legislation, it may be worthwhile to talk to a legal professional so that at least you can choose the right mechanism through which you should apply for your review of the decision that you are challenging. Thank you for watching, and in the next lectures I will try to cover the topics of the procedure for the appellate review in courts and also the standard of review.